Hi and welcome to this latest immigration law update video. In this video, I continue my series going through the Upper Tribunal reported decisions for 2020. And in this video, I'm looking at the decisions for October 2020. But I noticed that there had been an additional case added for September 2020 that I didn't cover in the previous video. So we're going to cover that as well. So that case is a case called Zulfiqar, and it's to do with foreign criminals and British citizens. Now, actually, when you read the head note, you would think it's just a technical decision looking at the Borders Act and the 2002 Act and Part 5A. But actually, this case raises some really interesting issues. The appellant in this case, it was a national of Pakistan, but he'd previously been a dual Pakistani British national, having been born in the UK in 1979 and lived here all of his life. The index offence in this case was a very nasty alcohol-fueled murder for which he received a life sentence, and the judge had recommended a minimum term of 15 years. So what happens, and if you have a look at paragraph 20 and following of the determination, you'll see that he applied to be repatriated to Pakistan under the terms of the prisoner transfer agreement. Now, the Ministry of Justice refused this application on the basis, because he was a British citizen, he could actually then go and serve the rest of his sentence in Pakistan and then re-enter the UK as a British citizen without then being subject to his license provisions. So that was rejected. So what the appellant then did was apply in 2011 to renounce his British citizenship. That was approved. So then he only held Pakistani citizenship, and then he applied again for repatriation, and that was unsuccessful. The appellant entered into another relationship with an individual called Z, who had his children, and that was the subject of the Article 8 consideration we'll look at in a moment. So in 2017, the appellant applied actually to resume his British citizenship following renunciation under Section 13 of the British Nationality Act. Have a look at paragraph 26 of the decision, and you'll see that that was refused on good character grounds. So therefore, deportation proceedings were launched against the appellant. And the deportation order was made under the 71 Act on the basis that he was not a foreign criminal by virtue of the Borders Act, because he held British citizenship, and we'll come back to that. The tribunal set out all the relevant statutory provisions from paragraph 31 and following, and then they look at the decision of the first tier tribunal, who dismissed the appeal. There were a number of challenges to the upper tribunal. One of them was that the judge had erred in rejecting the appellant's account that he was induced to renounce his British citizenship, and the upper tribunal, well, in fact, they reject all the grounds of appeal and find no error of law, but they reject that as just a disagreement. The rest of the grounds challenge the approach of the judge to the Article 8 consideration. And the tribunal consider whether the appellant is a foreign criminal for the purposes of Part 5A of the 2002 Act and Part 13 of the immigration rules. And you'll see that from paragraph 64 and following. But let's have a look at the head note. First, the tribunal say the meaning of foreign criminal is not consistent over the Nationality, Immigration and Asylum Act, the 2002 Act, and the UK Borders Act 2007. Now, we know the UK Borders Act, section 32, look at head note 2, creates a designated class of offender that is a foreign criminal and establishes the consequences of such designation. That is, for the purposes of section 35A of the Immigration Act 1971, the deportation of that person is conducive to the public good, and the respondent must make a deportation order in respect of that person. So that's the automatic deportation provisions. But look at 3, a temporal link is established by section 32(1), requiring that the foreign offender not to be a British citizen at the date of conviction. Now, he was a British citizen at the date of conviction. Therefore, the Borders Act didn't apply to him, and he was not a foreign criminal under the Borders Act. And that's why the Secretary of State had to ultimately pursue his deportation under the 71 Act. But Part 5A of the 2002 Act, and for anybody who doesn't know, that's 117A, 117B, 117C, which applies to deportation, and 117D, prescribes a domestically refined approach to the public interest considerations which the tribunal is required to take into account when considering Article 8 in a deportation appeal. Unlike the 2007 Act, it is not a statutory change to the power to deport, rather it is a domestic refinement as to the consideration of the public interest question. So essentially Part 5A is how Article 8 should be considered, and particularly in 117C, how it's to be considered in a deportation case. And Part 5A establishes no temporal link to the date of conviction. Rather, the relevant date for establishing whether an offender is a foreign criminal is the date of decision, subject to the exercise of appeal on human rights grounds under Section 82(1)(b) of the 2002 Act. So, even though the appellant in this case was not a foreign criminal for the purposes of the Borders Act, he was to be considered a foreign criminal for the purposes of Part 5A of the 2002 Act. And therefore for the immigration rules, because the immigration rules must be applied consistently with Section 117A to D Part 5A, and that was confirmed in the case of SC Albania from 2020. Also, it said at 6, in such a case, the weight to be given to former British citizenship is case sensitive. That is to do with what's said at paragraph 91, where for the Secretary of State, they submitted that the judge had taken an overly generous approach by giving substantial weight to the fact the appellant was formerly a British citizen. Now, the upper tribunals find that the judge did not err in giving substantial weight, and it was open to her on the basis that he'd been born here and lived here for 30 years. And they contrast that position with somebody who'd perhaps recently obtained British citizenship by deception. So the weight to be accorded to somebody being previously a British citizen is a case-sensitive weight. And in this case, the judge was entitled to give the case substantial weight. But ultimately, as I said, all the grounds were rejected and no error of law was found. So whilst this case, when you read the head note, may just seem a technical case, it does raise some interesting issues. And I've certainly had inquiries from solicitors in recent times about people asking about renouncing British citizenship and wanting to take up the prisoner transfer scheme. So worth having a look at. The case that is the true October case is the case of mixm gender identity, HJ Iran, El Salvador. And this is a decision by Upper Tribunal Judge Bruce, and a very welcome decision. This concerned a national of El Salvador. The appellant now identifies as non-binary. He previously identified as a homosexual man, but now identifies as non-binary. So Judge Bruce, throughout her decision, uses the gender pronoun mix and uses gender neutral terms throughout her decision. And she says, and it's in the head note, decision makers should, where possible, apply the guidance in the Equal Treatment Bench Book and use gender terminology which respects the chosen identity of claimants before them. Obviously, there will be cases where there will be justification for not following that guidance. For instance, where perhaps somebody's claim to be transgender has been expressly rejected as false. But otherwise, gender terminology should be respected and used. This was a fresh claim for asylum. The appellant's previous claim had been dismissed at appeal and found that they were not at risk of persecution. The appellant had lodged a fresh claim, which was based on their change of identity and appearance. They now wore their hair long and blonde, and there was a significant change in appearance and relying on country evidence. The new tribunal, the new first-tier tribunal in the fresh claim appeal, had also dismissed the appeal and found that the appellant was not at risk of persecution. Now, Judge Bruce addresses whether there's an error of law by looking through the lens of H.J. Iran, which is the correct legal framework. And she notes at paragraph 12, interestingly, that neither the respondent nor the previous two first-tier judges had applied H.J. Iran to this case. The first question, obviously, is whether the appellant is a member of a social group. And Judge Bruce criticises the first-tier judge because the first-tier judge had not properly considered the appellant's current identity and looked at that in making the assessment and not made proper findings on the current identity, and also therefore not properly assessed the social group that the appellant actually is part of. Judge Bruce also looks at the risk assessment and whether the appellant would be at risk of persecution. And there's a good exposition of the meaning of acts of persecution within the decision, but finds the judge erred in their consideration of whether there was persecution, on their consideration of the country evidence, and not properly considering all relevant considerations. So Judge Bruce sets aside the decision and then again looks through H.J. Iran to assess whether they would be at risk on return, and remakes the decision, finding that the appellant would now be at risk, however they are viewed in El Salvador. They were previously viewed as a homosexual man. They previously now identify as non-binary, but in any event, they would be clearly at risk of persecution in El Salvador on return. So Judge Bruce allows the appeal. So an important decision which has wider ramifications there from Judge Bruce. So that is the one decision from October plus the one that was later added for September. I'll be back in the next video looking at the decisions for November 2020, but I hope that's helpful. I'll put the head notes and the links below in the description to this video, and I'll post my slides on the Number 8 Chambers website if that's helpful. Thanks, everyone.